welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague Russell Berger from the Offit Kurman Labor and Employment Group. And this week we are talking about a really fun topic, contracts. Really exciting, always something everyone's always excited to talk about. But we're talking about just kind of some of the things to keep in mind when you're either putting out contracts into the world, sending them to other people, and then equally, if not more important, when you're receiving them from from other businesses or from vendors, or and when you're reviewing a contract. And while they're not always the fun, flashy thing to talk about, they are one of the more important functions of any business, and really important thing to make sure that they're buttoned up. So what are some things that people should keep in mind, Russell, when it comes to contracts?
Yeah, well, the first thing is that every word in the contract matters. There's probably some Latin term in the law for it, but there's this concept in the law that basically says that everything's in there for a reason, and we should interpret contracts with that in mind. That things aren't superfluous, things aren't redundant. Every sentence serves a purpose. So it kind of leads to a rule that I know, Sarah, you use as well when reviewing contracts or writing contracts, and that I use as well, is everything in there. I have to know why it's in there. There has to be a reason. I have to understand it, and I won't send a contract out. I won't review a contract for a client, send it back to the client unless I know why every sentence is in that contract and can explain every sentence in that contract and what its purpose is to a client. And that's really what I like to do in terms of reviewing a contract, is to go through that process, make edits, make comments, have questions. And then I always think it's a good idea, particularly in the employment space where the contracts aren't terribly long, to just walk through the contracts, whether it's an employment agreement, a severance, a restrictive covenant, whatever it might be, to walk through that contract with the client and say, look, this is what's happening in paragraph 1. This is why it's here. This is what's happening in paragraph 2. And just to make sure that the client understands everything in the contract, because ultimately a lot of what's in the contract might be fine from a legal perspective, but it might not be from a business perspective. So it's really, a contract's really creating legal formality around a business decision. And we as lawyers certainly bring the legal formality review, but it's really going to be up to the business owner to make that call as to whether it's a good business decision or not. And a lot of what we do is to try to explain it, highlight it, make it clear what those business decisions and business questions are in a contract.
Yeah, and I think this is, kind of as I noted at the beginning, it's especially true when clients are receiving a contract, because often, so, if we put together a contract for a client, we're doing it with our client's best interests in mind. And normally we've gotten the parameters of whatever the business pieces are to the deal in our drafting process. And we've looked at it through the lens of our client, and whatever we're turning over to the other side is with our client's interest in mind. But when a client's receiving a contract, often it can look like it's all the great legalese and everything that you would normally see in a contract, but it's drafted with the other side's best interests in mind. And there might be some things within that contract that aren't actually well drafted or are advantageous to the person receiving it. So, for example, we often see indemnity clauses that are one-sided, where the person providing the contract is indemnified, or the company providing the contract is indemnified, but not the person receiving it, or the entity receiving it. So a lot of times we'll take that and make it mutual, or attorney's fees shifting, for example. Say, oh well, if the person turning the contract over could say, well, I get attorney's fees if I win. Well, we would turn around and say, well, those should be whoever wins, whoever the prevailing party is, should get the attorney's fees. We don't want it to be one-sided. So even though it might look great and look glossy and lawyerly, it's still very important to really go line by line and engage in that process that you described, Russell, of really having a good understanding of what does everything mean.
Right. Yeah. And that's kind of the challenge. You made the point that we draft these for clients, so we draft them as advocates. We don't draft them as neutrals, and that's exactly what we do. I mean, I've certainly drafted plenty of contracts that were one-sided because the client had the leverage to be able to, get the other side to sign an agreement like that. And why wouldn't we do that? That's our job, is to serve our client, not to find a neutral, agreeable contract. Um, but it's just all the more important, like the point you just raised, when you get offered a contract, just signing it. Oh, this looks simple. I think I understand it. I'll just sign off. I don't really get all this. It just looks like a boilerplate at the end. I'm just going to sign it. Now, that's probably not a great decision unless you truly have reviewed it and do understand it. I mean, because of the provisions you mentioned, is indemnification mutual? Is there prevailing party fee shifting language? I mean, even like the choice of law and the forum for when you're going to dispute, the rules for a dispute over this contract are important, because they can really create advantages or disadvantages one way or the other. So I mean, those are really important things, even though um, they're not substantively heavy. They are very relevant, and it's really important that you at least give some thought and you know what you're signing. And if someone's got a bunch of bargaining power over you and you're going to sign it anyway, then so be it. But I think it's always advantageous to kind of know what you're giving up, and how much that other side's bargaining power is getting them.
Yeah. Well, and also, sometimes you get a contract that's not so nice and neat looking. And that's really important as well, because as you mentioned, the role of making sure that everything that's in there needs to be in there. We know what it means. There's a clear understanding. I mean, usually when people are entering into a contract together, it's kind of like a marriage, right? They're happy, everything's good. We're excited about the deal. Like we want to engage in this transaction together. That's the general sentiment usually. And then when something goes awry and people look at the contract, well, that's when things can get a little bit dicey. People aren't on the same page, and maybe they're arguing over something. And so you want to make sure the language is really clear. And I really am amazed at the amount of contracts that come across my desk sometimes that people have signed where they really don't have a good understanding of a clause. And now this disagreement or this litigation is turning on a phrase that is so poorly worded that no one has any idea what it means. And then us lawyers, we get a hold of it and we make it mean all kinds of things. So, it's really it's really good to be really diligent. Especially sometimes people are pulling forms off of offline and they're really sloppy. And that really can create such a nightmare when it comes to the back end and trying to enforce those things.
Yeah, absolutely.
Well, thanks, Russell, and we'll see you next time.
Thanks, Sarah.